Among the remarkable events of this year, one occurred on the evening of June 17th, 2015. A gunman, whose name is not worthy to be referenced here, killed 9 persons during a prayer service at Emmanuel African Methodist Episcopal Church in downtown Charleston, South Carolina. The morning after the attack, police arrested him. He confessed, and he admitted that his motive for the shooting was to ignite a race war. Quickly, photographs of the man were circulated in which he donned racist symbols and waved a Confederate flag. The very morning that he's arrested, the day after the shooting, the 9 justices of the Supreme Court decide to proceed and announce their ruling in Walker versus Texas Division of the Sons of Confederate Veterans. In many ways, their decision to proceed under the circumstances was remarkable, because what they were about to do is announce a 5-4 decision on what is a relatively minor legal aspect of these issues. Texas offers all its residents a choice. You can have either the general Texas plate on your car, or you can have a specialty plate. You can propose a design for your specialty plate, agree to pay the extra costs, and if the Board of Motor Vehicles approves the design, you may put it on your car. Now, Texas, for reasons that I find difficult to explain politically, said no to a Confederate battle flag. I must confess, because of my suspicion of Texas politics, I would not have thought that would have been the result, but they said no. And the Sons of Confederate Veterans sued, claiming that their free speech rights had been violated. The federal district court that heard the case ruled for Texas, and the Fifth Circuit reversed, ruling for the Sons of Confederate Veterans. The United States Supreme Court took the case, and that morning, the morning after the shooting, they announced the result. The justices divided 5-4, not itself unusual. But interestingly, Clarence Thomas joins the so-called liberals, upholding the principle that this is a matter of government speech, not private individual speech. This means that the majority opinions are saying no to a free speech claim, and the quartet of dissenting justices, led by Justice Alito, were upholding classic libertarian visions of free speech. Now, in most ways, this is a very simple issue, turning on disputed points of fact, addressing a principle that all 9 justices agree. If the specialty plate is the speech of an individual, then the denial by Texas is viewpoint discrimination and unconstitutional. But if, on the other hand, the specialty plate is government speech, the speech of Texas, then Texas has a right to define its own message, or at least those messages with which it's supposed to approve. Now, all of the justices have, in one case or another, endorsed this idea that government speech is beyond the free speech principle, that government may edit its messages, write its memoranda, write its own speeches, and have its own decisions with regard to viewpoint. But the problem is the factual issue. Is that what's going on here? Or has Texas, through its loose editorial handling of a wide variety of specialty plates, essentially created a public forum, a limited public forum, but one in which individuals can say what they want to say and communicate their messages? Well, the Supreme Court, by that one vote, said a Texas license plate is Texas speech. The reasons are historical. States use the plates to communicate messages about tourism and how great their state is. They're often closely identified in the mind of the public with the state. It's essentially a government ID on each car. They're mandatory. And most important, Texas retained power of final control, final approval over designs. Now, Justice Alito wrote a solid dissenting opinion, which is a joy to read. It's well written, it's witty. I ultimately think it's incorrect, but along the way he makes a lot of good points, some of which will be of great interest to this particular community. He writes that the court holds that all the privately created messages on the many specialty plates issued by the state of Texas convey a government message rather than the message of the motorist displaying the plate. Can this possibly be correct? Well, he says it can't be. And to do that, he comes with a multiple set of examples trying to distinguish the license plate case from a case that he wrote dealing with public monuments on state capitol grounds, the Sumim case. And along the way, he points out a fact which you may not know. There are OU fans down in Texas who have sought to have specialty plates, and Texas has approved it. And Alito says, can it possibly be that Texas has approved such treason in these plates? And his answer is, of course, no. Therefore, the fact that OU messages are endorsed and approved is proof of a public forum. While this is a remark that entertains, it's not one that persuades. More to the point, he says the decision of Texas to say no to the battle flag plate is very definitely, very obviously, viewpoint discrimination. And more or less, the Department of Motor Vehicles said it. It's a controversial symbol. Many people see it. They react to it, and so they don't want to approve it. So Texas was in the unusual position of saying almost every other message is okay, just not that one. Well, it was only when you get to that issue that some of the issues surrounding the shooting are addressed. Because what was happening, as Justice Alito points out, is Americans were debating the ambiguity of this rebel flag. For some, it's a symbol of heroism and valor and regional pride. For others, it is a symbol of hate, white supremacy, and discrimination. And truth be told, I think it's just clear as day that both are right. There are people who endorse it for their own personal motives, and there are people who understand it in light of their experiences, and it is impossible to say that either is completely correct or incorrect. No doubt, it's viewpoint discrimination. And in the cases that will come up in the future, when we are talking about private forums, when we are talking about individual speech, those of us who recoil at the rebel flag, and I am one, must recognize that it must be treated in precisely the same way as a burning American flag or some other symbolic expression with which we disagree or take offense. Meanwhile, other events are happening as this opinion is absorbed by the American community. The gunman is, as I said, arrested, brought before a hearing, charged with a crime, where he must first appear before the families of the victims, who movingly forgive him. Single most amazing event of the entire episode. But then something else happens, something I never thought I'd see. South Carolina decides to take down the flag. The flag is on the state capitol grounds with special systems that prevent it from being easily removed, and a special law that cannot be repealed except by supermajority. And this state, the first state to secede, the home state of Calhoun, John C. Calhoun, whose name is given to the road on which the church rests, Well, the ironies are just thick. The state remarkably decides it's time to take down the flag. Before a month is over, the South Carolina flag is down, relegated to a historical museum. And in American society today, a museum means it's going to be obscured by the great historical amnesia of the entire nation. This means that we're going to be left with debate over private speech. As I drove back from North Carolina after spending a summer this year, I have to admit I saw more Confederate flags than I saw last year. There has been a backlash. Along Highway 81 and Highway 40, I regret to tell you that some people are making a statement. In doing so, they are rejecting the choice and the leadership of General Lee, who wrote, "I think it wiser not to keep open the sores of war, but to follow the examples of those nations who endeavored to obliterate the marks of civil strife and to commit to oblivion the feelings it engendered." The ladies and gentlemen that are flying that flag are in fact corrupting what it originally stood for, solidarity on a battlefield, by turning it into a contemporary political symbol. They may claim it's a symbol of martial valor and regional pride, and it might have been that once, but over the period of the late 20th century, after Brown versus Board of Education, it was resurrected as a symbol of white supremacy and resistance to civil rights disputes, or civil rights policies. And for that reason, we'll be left with a much more delicate, challenging, but important task of reminding those who fly that flag what it really means. It is ultimately a symbol of treason, and it is ultimately a symbol of discrimination. And whatever the intent of the people who put it up, that symbolism cannot be ignored or denied. Thank you very much.
Freedom 101 is made possible by generous support from the University of Oklahoma Alumni Association. Freedom 101 is a program of the Institute for the American Constitutional Heritage at the University of Oklahoma. For more videos and podcasts, visit freedom.ou.edu.